C.I.A. Services Seminar Series. Tonight we're going to be talking about advanced topics for board members, one of my favorite seminars. This is actually the sixth one that we've done by a webcast. All of the other 5 that we've done so far are posted in YouTube, they're on our website, and all those good things. Before we get started though, I do want to introduce my partner here who is going to be taking your questions. Anytime you have any questions, go ahead and just type them into the chat box. We'll either answer them immediately or Tina will chat back to you. So over here is Tina Jameson. Tina is one of the founders of C.I.A. Services and also the branch manager of our Bandera office and our San Antonio office at this point. So, Tina, thank you so much. Tina may make a special appearance in a little bit in another part of tonight's presentation. But let me go ahead and get started with what our agenda is. We've got a lot to cover tonight. As I mentioned, this is actually one of my favorite seminars. Topics that you as board members don't get to see too often. And so I'm going to describe all of these things in a way that will hopefully resonate with you, that you'll be able to understand what the topics are about, and when they do come up on an infrequent basis, you'll be ready to understand and know what we're talking about. So here's the agenda. As always, we're going to start with the basis of authority. That is the basis for everything we do, what allows an association to govern its the things that are happening in the community. So we're going to start with the basis for authority, and then we're going to get into a long section on working things out. And in just a moment we're going to get into working things out, and there we're going to deal with reviewing decisions, hearings in front of the board of directors, mediation, arbitration, litigation, all of those ways that we take care of things when we have to go that far. We're going to touch on something called affirmative defenses. Affirmative defenses are things that a defendant could raise if we have to go to trial, but I want to talk about them more from the standpoint of how we avoid getting into a situation where we're providing those defenses for someone that we may have to go into court with. We'll talk about foreclosures. That's kind of a fun part. That sounds kind of morbid to say it that way. The discussion we'll have about foreclosures will be interesting. Let's phrase it that way. Quickly, we'll go through bankruptcies, and we're going to finish up with insurance, with real examples of claims that may occur for an association, and we'll go through those. So let's get going. The basis for authority. If you've been to any of the other webcasts, you already know this stuff, so we're going through it quickly. Each association has a set of governing documents. These are your documents, they've got your name on it. And so we start with the things that deal with the association itself. An association is created through a Articles of Incorporation or Certificate of Formation, depending on when it was created. It's a very short document that just lays out the overall purpose for the association, and it's filed with the Secretary of State's office to create the association. Once it's created, whoever the developer is will put together the first set of bylaws. The bylaws are the standard operating procedures for the association. It includes things like how many board members there are, how long they serve, how they're elected. It goes into committees and a variety of things like that that all have to do with how the association, that corporation, operates. We then get into the things that govern the use of the land by the owners, by the members of that association. And the main thing there are the deed restrictions, commonly called, but they go by many names. You'll hear me refer to that document as the CC&Rs, Covenants, Conditions, and Restrictions for the land. The plat also, which is filed by the developer when they first start deciding to divide up the land and sell it, also has restrictions on the land. So a plat, for example, would have things like setback lines, utility easements, and things of that sort. Those things that I've just talked about are all created right at the beginning by the developer. Certificate of Information and bylaws, the plat, and the CC&Rs. A developer may do a few other things, but most of these other things generally are done and supplemented and amended by subsequent boards of directors. Today, you as board members may be adopting things like architectural and deed restriction guidelines. Whenever the state law changes, there are opportunities for us to create new guidelines, or we're mandated to create new guidelines. Finally, getting back into how we operate, an association will have policies, procedures, rules, and regulations. So if you have a swimming pool, you have rules that say don't run on the deck, and things of that sort. If you have private streets, or you're a commercial enterprise or a condominium association, you probably have parking rules. Policies such as collections policies, procedures, deed restriction enforcement procedures. These are all yours. These are all customized to your needs as an association. Nobody else has the documents that you have. Now let's move on to what governs all associations, either directly or assist association in carrying out its mission. So the first one are local government ordinances. So these are things, if you're within a city, cities can pass ordinances that can really help associations. For example, there's zoning and building codes that can assist if you have a dilapidated house, for example. Health and safety type things. If you've got a swimming pool in the backyard that is unmaintained, that's a health issue that a city can help with. If you have animals running loose or in packs, that's something that city ordinances can help with. Annoyances and appearance items are all things that are covered under local government ordinances that can assist an association. Sometimes, speaking of San Antonio, there are some ordinances that create confusions with associations. One that's important in San Antonio now are the laws relating to owners having chickens on a property. Many restrictions say no livestock, poultry, etc., etc. Chicken is definitely poultry, and so how does a city ordinance which allows chickens interface with a set of restrictions that prohibit poultry? We actually covered that in another seminar, but briefly, the more restrictive of the two is going to be what prevails. So the city says, yes, you can have it. Your specific restrictions say, no, you can't have chickens. Yours will prevail in your community. Moving up a little bit higher into the state laws, the Texas Property Code is what governs both property owners associations, condominium associations, different chapters in that code. And that, in some cases, strengthens an association's ability to do its business. In other cases, it makes it either more difficult or specifically prohibits certain things. So, for example, under the state property code, you cannot prohibit an owner from having solar panels on their roof, even though your ACC prior to 2015, or 2011, excuse me, may have felt that solar panels are unacceptable. When we move all the way up to the federal laws, there are a number of things which assist us, or in some cases provide challenges. Telecommunications Act, for example, that came in the 1990s is one where many restrictions from before the 1990s, the 70s and 80s, specifically prohibited satellite dishes. Telecommunications Act says, no, you can't do that. And so I just wanted to very briefly go over your own governing documents and then the things that sit on top of or besides your documents in terms of helping or hindering an association in terms of carrying out what needs to be done. But in all cases, we absolutely need to heed whatever other laws are out there. So I'm not at all indicating that things in the Texas Property Code interfere with our mission. They simply indicate that there are certain rights that are important for the citizens of Texas, that they must be allowed to do certain things. Well, now let's actually talk about the big topics we're going to deal with tonight. And those are working things out when we end up with conflicts. But before we get into how we work things out, I really want to emphasize that the vast majority of all the issues that come before an association on a day-to-day basis are really resolved on a routine basis. And board members oftentimes can become jaded because the only things that are brought in front of board meetings are the problems. The only things their neighbors bring to their attention are the problems. And you don't hear as much about the fact that we don't have these particular violations going on, that we are able to pay for our bills because the collections are going well and things like that. So just a few numbers that are shown on this particular slide. On our average association, at least 96% of all accounts are collected by the management company without having to go to the attorney, and more than 98% are taken care of without going to litigation, which is what we'll be talking about later. And so the vast majority of homeowners really are looking to their obligations, and they understand them, and they take them seriously. When we move on to deed restrictions, if you went to that particular seminar, over an extended period of time, looking at our company statistics across all of our communities over a 10-year period, there were like almost 700,000 total violations that we worked with during that 10-year period of time. And 99.7% of all of those never had to go to an attorney. And a very high percentage in the lower 90s were handled with just a first or a second letter, and then in the high 80s or low 90s with just a single letter to an owner. And again, that is successful. That's 99.7% that we didn't have to work out at a higher level that we'll talk about in a moment. And then home improvement requests. 88% of all home improvement requests over the last 10 years, and we're talking thousands and thousands, were approved or conditionally approved right from the get-go. And the ones that were disapproved generally were for things that could be resolved in a resubmission. So things are getting taken care of. However, not 100%. And so the ones that are not routinely taken care of are where we need to take more action and try to work those things out with the owners. So let's look at the escalation of working things out. The first thing is to review a decision. So for example, a committee makes a decision about something, the management company makes a judgment about something, and the owner disagrees. And so there's a very smooth, easy process for asking the board to review that issue and make a decision. We're going to talk about all of these in a little bit. The next one, the next higher level, is where we get a little formal. This is under the Texas Property Code, Chapter 209, provides owners with an opportunity to meet with the board of directors to try to resolve an issue but certainly to understand the facts associated with the issue. And that's called a TPC 209 hearing, or a hearing in front of the board. That's something that most board members have been through a hearing at one point or another. The next thing is mediation. So we've not been able to resolve things. It's probably gone to the attorney at this point. And so prior to litigation, generally a court will order mediation. Mediation, if you've not been through it, is something I'm going to be describing, how it feels to be in mediation, what actually happens there. Mediation is actually pretty nice and often successful. The next level up from that is called arbitration. Arbitration simply is essentially a trial that doesn't happen through the courts. A decision is made by someone who is listening to the testimony and makes a ruling. Finally, litigation is where you use the courts to solve something. We're going to spend quite a bit of time on what we refer to as the anatomy of a lawsuit. So you'll understand what a lawsuit is all about, why it takes so long, and why it can be so expensive. And therefore, why we'd want to avoid lawsuits if we can resolve them without having to go to court. So let's get started on the first item, which is review of a decision by the board. So it's important to understand that the board of directors is always the ultimate authority, and an owner has the right to ask the board to determine if that committee or that management company is interpreting things as the board wants to be done. So for example, if the ACC, the Architectural Control Committee, disapproves something or conditionally approves something and the owner doesn't agree with the conditions or doesn't agree it should be disapproved, informally, they may ask the board to look at this, but more often on an ACC disapproval, we actually go to the next step, which is an official hearing in front of the board of directors. But if it's simple, it could be done just by communication with the board. What if a late fee is applied to someone's account? As part of the standard collections process, the homeowner doesn't believe there should be a late fee on the account, and then a decision is, the board of directors or the management company reviews that and determines whether or not to waive that late fee. How about the management company sends a deed restriction letter asking the homeowner to paint their home, and the homeowner thinks that it doesn't need to be painted, and they would like the board to review that assessment. Or how about the pool company enforcing disciplinary action on someone who has violated the pool rules? So those are all examples where we may want to, an owner may want the board to intervene and make a decision on those. It's not formal because your documents most likely don't have anything in there regarding this low-level review. They may have something, and certainly state law has something, regarding the right to a hearing, which is the next step, but we'll get to that in a moment. So if an owner does want something reviewed, they should always make that request in writing. In other words, we don't need the management company or a committee or someone else putting words or interpreting what that person is asking for. So we always like it to be in writing so the board is seeing exactly what that owner wants. And it needs to be complete. So for example, if someone is asking to waive late fees, just to say, please waive my late fees because I shouldn't have to pay them, doesn't really give a whole lot of information for the board to make a decision. Whereas if they say, I didn't get the statement, or I was having difficult financial times, at least something that will let the board know the basis for why the request is being made. And so reviews of that sort are generally handled either by email communications. So if it originally comes to the management company, we send something to the whole board of directors that summarizes what the issue is. You have the owner side of it. The management company will provide any basis in the governing documents or the rules or policies of the association that may be related to this particular issue. The board makes a decision, and then there's a written response back to the owner as to whatever the decision was. Or if you're going to have a meeting coming up shortly, then it could be handled at a board meeting. It's not necessary generally for these low-level things for the owner to attend a board meeting for this particular issue, but they're certainly welcome to. And if they do attend, these sort of things almost always would happen in executive session because they deal with an owner's account, personal information about the owner, maybe a child who violated pool rules, or things of that sort. But a decision can be made. The owner feels good that they weren't stopped at that first step, whether it be the ACC committee, the pool company, the management company. They feel good that they were able to have someone else look at this issue and make a decision. So these relatively low-level reviews have a positive impact in that an owner feels that the system is fair by having another party look at their concerns. So a couple examples, we gave some earlier, but the ACC, for example, requires, they approve a house to be re-roofed, but the house has a detached garage, and the ACC says the whole roof, including the detached garage, must be re-roofed. The owner, however, disagrees. He feels that the garage is still in reasonable shape, and so doesn't want to do the garage also. That would be an example that the board could come back and in an informal basis say, no, we believe that it needs to be changed. You may already have guidelines in place that say on detached garages that if you're re-roofing, both the roof of the house and the roof of the garage must be done at the same time. So if you have all of that, then that's an easy response back to them if they want to elevate it to the board. Some of these are taken care of by the management company. We would send them the documentation of the guidelines that say both parts need to be done at the same time. How about a late fee? The owner feels there are extenuating circumstances. They were out of the country. The mailboxes, the cluster mailboxes had recently been vandalized, and so mail wasn't getting to people. This is a real example that we've had in our communities where recently in two of our communities in San Antonio had a lot of mailbox vandalism right around the time the assessments were going out, and the board was very willing to waive late fees for someone who would point to that as the reason that they didn't pay their original assessments, if that owner had generally been paying on time. Another example would be we send a deed restriction letter to an owner saying, as I mentioned before, you need to paint your house. And the owner says, it doesn't need painting, it's rough cedar siding and it's supposed to look that way. Well, maybe it is, maybe it isn't, but the board of directors could go by and indicate whether or not they felt that was true. If it was uniformly faded, maybe the board would go for it. But if only portions of it were discolored or a lighter color, they may come back and point out to the owner that it's really not uniform, and so if it were simply the look it was supposed to be, maybe it would be more uniform. That may be their logic. And then finally, pool rules. The pool rules may say that anyone who is under 12 years old, if they can pass a swim test, they can go to the pool without an adult. That may be a rule that a community has. And there's a 9-year-old, great swimmer, got lots of medals from being on the Mary Meadows swim team. However, their parents are kind of indignant that we would ask this gold medal winner to take a swim test. And so they kind of refuse to take a swim test so their daughter can go to the pool on their own. That would be something that the board could say, okay, we'll waive the swim test for her. Or they could explain to the mother, we're not picking on you, we're just trying to be uniform. She can get in there and do the swim test before we're done with this conversation. So that's an example of a low-level review where we just try to work it out, give that owner the right to have someone else hear their story. And then we get into things that are a little bit more formal. And so something that's a little more formal would be the hearing in front of the board. This is provided by the Texas Property Code, Chapter 209, that allows any owner to request a hearing in front of the board for these 4 different types of situations. If rights are going to be suspended for using the common areas, in other words, if we're going to kick someone out of the pool, we need to give them the right to a hearing before it becomes permanent. We could temporarily kick someone out of the pool subject to the hearing, but if we were going to permanently kick them out, we would have to make sure we had that hearing. Secondly, if we're going to file a lawsuit for something other than assessments, we need to offer a hearing. Keep in mind what that says. In other words, if we're going to file a lawsuit for unpaid assessments, there's no requirement for a hearing under the law. If someone asks for one, we may want to certainly get together and talk about it, but this deals with lawsuits that are not related to collection. So basically deed restriction lawsuits and a few other things, but mostly deed restriction lawsuits. If we want to charge an owner for property damage, so recent example, in one of our communities, a vehicle was parked on a street, a very nice Corvette was parked on a street right across from the swimming pool on a little bit of a slope in the road. The owner forgot to put on the brake and put it in neutral, jumped out of the car, went into the house. The Corvette decided to roll down the street, ran into the association's bulletin board and tennis courts, and created quite a bit of damage to our stuff. The Corvette, you can imagine that the fiberglass on the Corvette bumper was also damaged. So before we would be able to charge them and have those charges stick to their account, we would need to offer a hearing. And then finally, if we have a community that allows fines to be placed for deed restriction violations or violations of rules, maybe parking rules or something like that, we need to offer a hearing. So it works this way. When we're about to do any of those things, we need to send that owner a certified letter, or under the law it's actually referred to as a letter by verified mail. We won't get into why they changed the wording on the law, but think of it in terms of we need to send them a certified letter that notifies them of what the issue is, what we plan to do, the issue being your Corvette damaged our tennis court fence. We plan to charge you for the cost of that damage and offer them a hearing in front of the board of directors. The owner has 30 days from receipt of that to request a hearing. If they don't request a hearing, then we've fulfilled our total obligation to offer a hearing. We don't need to have one, we just need to offer it. If they don't accept that request, we're done. If they do request it, then we need to hold that hearing within 30 days, in reality within 40 days, because we can, either we or the other party can ask for an extension of 10 days. And we must let them know 10 days in advance of the meeting, of the hearing. Recognize that the law does not require us to come up with a date that works for everybody. We can simply say it's going to be on this particular date, give them at least 10 days advance notice, and hold that hearing. In most cases, you want to work out a date where they can be there. Hearings are a great way to resolve problems. And so you really do want to try to come up with a date that will work. And if that date is 50 days off in the future, it's the next board meeting that's normally going to occur, and they can make that meeting, great. You keep everything on hold until then, and you hold the hearing at your next meeting. Now, one of the very important things that's right at the bottom of this slide is this, that if you do not offer a hearing, if you don't offer a hearing, and similarly, if you offer a hearing, they request it, and you don't hold it, then the association may not recover any future legal fees that may be associated with this issue. So if you end up not offering them a hearing and decide you want to file a lawsuit regarding this particular issue, their attorney is going to stand in front of the judge and say, Chapter 209 says they must offer a hearing or they cannot recover legal fees. And they're right. We may get a judgment, but that judgment will not include the $5,000 or $10,000 or $20,000 worth of legal fees we may have spent to get to the point of judgment. So there's not a specific penalty in the law. There is a consequential penalty of what I just said. So hearings are extremely important for two reasons. One, often they result in a resolution with the owner, just because you got together and talked and maybe worked out something that was going to be acceptable. But secondly, if you don't hold a hearing, there can be a big financial penalty to the association by not being able to collect any legal fees that may come after that point. A demand letter, another demand letter, filing a lawsuit, all of those things you would not be able to recover. So, you've probably been through a hearing, many of you have, but what the law says, as I stated earlier, is the purpose of a hearing is to discuss and verify the facts and resolve the issue, if possible. But one of the things that will occur there, even if you don't resolve the issue, is you will have been able to make it very clear through a conversation with that owner exactly what you're expecting. So there won't be any misunderstanding of what resolution the association would like. But often, just by talking, just by going through things, the owner will understand why this is important and voluntarily say, yep, I'll do it, maybe I need a little more time. Or they'll bring up an option that, well, what if I move it over here? Would that be acceptable? And the board will say, oh yeah, that's all we needed you to do is get it behind the front setback of the house. So by moving it by 5 feet, we're all going to be happy. So you come up with a resolution. So the owner has requested a hearing. You all get to the meeting, the board gets to the meeting, and the owner doesn't show up. That can happen. Maybe they have a valid reason, maybe they don't have a valid reason, but there could be the situation where the owner doesn't show up. The board absolutely needs to hold that hearing. You call the hearing to order, you announce that the owner is not there, you close the hearing, it gets in the meeting minutes that it was held and the owner was not present. If you do that, you have then fulfilled all your requirements to offer a hearing, to hold a hearing. Now, if they really had a reason, something happened and they just couldn't get there, then the board should consider rescheduling it, holding it at a time where the person can be there. Because again, your objective here is to resolve things in a manner that avoids potential litigation and all those bad things that can happen there. The hearing is held in executive session. The property code, the way it's written, and I had one of our board members just last week question the executive session portion of it, but there's two sections of the property code, so let me just clarify this. One of them says that if you are going to have an appeal of an ACC decision, it must be announced for an open meeting. In other words, you've got a meeting that's announced to the membership. You need to have on the agenda that there's going to be a hearing related to an appeal of an ACC issue. But it also describes that issues of a personal nature will be in executive session. And so the really weird thing about that, what appears to be a conflict, is if the only purpose for this meeting is to hold a hearing, in other words, you're holding a special board meeting simply to do a hearing, then you must announce it to the whole membership saying we're having a hearing. And as soon as you get to the meeting, if anyone shows up, and you'll always want to tell them this is going to happen, but if anyone shows up, you immediately say, welcome to the meeting. Would you please leave because we're going to have an executive session? And so it's not a very comfortable situation if that's the only thing that's happening. You tell everyone you're going to have the meeting and sure you can show up, but you immediately tell them to leave the room for executive session. And the last thing I want to say about hearings is that there's no requirement under the Texas Property Code that you respond either at the hearing, although it's hard to discuss and verify facts if you're not talking to each other, but there's no requirement that you respond with a decision either at the hearing or even after the hearing. However, we strongly believe there must be a letter that is issued from the association after every single hearing. It may say, as we discussed, here is what everyone agreed to. It may say, we heard your points, there was not an agreement, and we continue to ask you to do whatever it is. Or it could be, the board discussed this after you left, they haven't come to a decision, so we'll continue to be on hold and we will provide you a decision as soon as that decision is made. But we always want to get back to that owner who took the time to request a hearing, to come to the hearing, and to know the results, if any, of the hearing. The next page simply shows you the language that goes into letters where one of these things are happening, where we're threatening a deed restriction lawsuit, where we have property damage, where we're kicking someone out of the pool, or we potentially will be implementing fines. Those, again, are the 4 areas where a hearing must be offered. And so the red box that's on your screen simply shows in the first part the language required by the Texas Property Code that hearings needed. The second paragraph is something else the Property Code threw in there, which has to do with people who are on active duty, simply a notice that must be on there. And so both of those go by certified mail, as you can see on this particular item, and that's the language that offers the hearing. I won't go through this page, but whenever there is a hearing, we put a memo in the board package for the board to kind of refresh everyone as to what a hearing is all about. And this language right here is what the presiding officer, the president, would say at the beginning of the meeting to kick things off. The the president says that, turns it over to the community manager to give a very brief summary, just the facts and just a couple sentences worth of the summary, and then turn it over to the owner to present their information. The hearing has a time frame on it. Most hearings can be totally complete in a 15-minute period. Sometimes they might be longer, sometimes they may be shorter. But we in advance, when we invite the people to the hearing, let them know what the expectation is, what the format for the meeting is, that they don't have to represent everything because the board members will have seen everything that they have sent so far with all of their information in it. So they can concentrate only on their high points or any new information they want to present. This is one of my favorite deed restriction pictures that resulted in a hearing. And this is one where there truly was no reason for a hearing, but the owner wanted one. And the owner disagreed that there was anything wrong with their fence that needed to be repaired. And so it was a relatively short hearing. Because this was back in the days before we had digital photos and things like that. And so, you know, we walked into the hearing with a blown up picture taken from the street adjacent to the property, and there wasn't a whole lot that they could say at that point. Well, let's go ahead and move on to mediation. In mediation, mediation can be done at any point in the dispute, before a lawsuit is filed or after a lawsuit is filed. And most courts are going to, these days, are going to require mediation before a judge is going to set a hearing in front of the judge. So mediation is something that we all get used to doing. It's a nice step that can often resolve a problem. Mediation is available through a variety of dispute resolution centers in counties. There are sometimes mediation through Better Business Bureau, where they refer it to a mediation center. Often the person doing the mediation is either a law student or a young lawyer who might be doing it. So it's someone who has a little bit of training in the law, but it's not necessary to be an attorney to be a mediator. The costs for mediation are generally quite reasonable, and sometimes they're even free. And for the benefits that can result from mediation, it's well worth it. An important thing to remember about mediation are these two items. Mediation is not binding. There's nothing that forces anyone to reach an agreement at mediation. And in addition, any discussions that are carried out in mediation, any offers that may be tendered to the other side in mediation are confidential. Those things cannot be introduced if you end up going to trial. Those things cannot be introduced as evidence in the trial. They are simply settlement talks, and they're confidential. Why does mediation often succeed? For a number of reasons. One is, first of all, it just gets the parties talking to each other. If they haven't talked to each other up until this point, if there wasn't a hearing in front of the board, sometimes just getting in front of each other and understanding the other person's side can result in some sort of a resolution. But what's most interesting about a mediation is how it actually occurs, and I'm going to describe that in just a second. But the mediator is there to act as an impartial third party. And what they do is they try to point out every weakness on your side of the case. And they go to the other side and they do the same thing with them. So they're trying to put some reality into the situation for each side, and both sides end up getting a little bit of a preview as to what it's going to be like if they actually go in front of a judge. In other words, what are the weak parts of their case? What are the strong parts of the other side's case? And that provides a little bit extra incentive to settle this before we spend a whole lot of money going through a full-blown trial. So if you've not been to mediation before, this is how it works. You have both parties and the mediator come into a room, and they all sit around a table. And most likely both parties have their attorneys there. From the association side, it's generally a member of the board and the community manager. Both sides walk into mediation with the authority to make a decision. That's one of the things you sign right at the beginning, that you have the authority to make a decision. So prior to mediation, the board would want to get together if the president is going to be there, or the manager representing the association, or just the attorney representing the association. That person walking in there needs to know the limits as to what the board of directors would approve, or have a hotline to everyone that they need to call immediately to approve something. The mediators don't quite like that approach, but if that's the only thing that's available, that's what happens. And so they all get into the same room, sit around the table, everyone makes an opening statement. The mediator describes the rules of what's going to happen. One side makes a statement, the other side makes a statement. Then the mediator sends the two parties to different rooms. The mediator goes to one room, hears more detail, and then starts attacking that party. Starts telling them all the things that are wrong with what they're asking for, the legal problems, asks them all sorts of things that show them all sorts of weaknesses, and asks them what they want to do. Then goes to the other room, tells them about all their weaknesses, and then offers whatever the first party was willing to do. And they keep doing that back and forth, this shuttle democracy, if you will, to try to get the parties to get to a point where they could come up with something they would both agree to. So that's how mediation works. It's interesting to watch the process, and it's a little bit difficult to hear how bad your case is, even though you think it's wonderful. There are always things the other side will say, we're going to attack this particular issue, and the mediator's telling you right up front, they're going to attack this issue, and I believe them. So it's really a nice process to get to a resolution where you shake hands and resolve the issue. When we get into arbitration, arbitration is something different. It's not common at all for associations disputes to be handled by arbitration. But there are some cases where an association would go into arbitration, not against owners, but for example in insurance. Insurance policies almost always have an arbitration clause. In other words, if you don't agree with what the insurance company is offering, you don't get to sue them. You have to go into a binding arbitration situation. Some contracts sometimes have that. And so in arbitration, similar to a mediation, you go before a third party, but it's much more like a trial. You're all in the same room the whole time. You present information and evidence to the arbitrator, who often has legal experience. Many times it's retired judges who end up being in mediation, or excuse me, in arbitration. And so each presents their sides, there's examinations and questions and everything else. At the end of the day, the person who is doing the arbitration makes a decision. They make a ruling. Whatever ruling they make is binding. There is no appeal of an arbitration decision. It is binding on both parties. And that's it. You're done. So why would you ever want to do arbitration? Well, the costs are equally shared, and it is much cheaper than a full-blown trial. And so arbitration has its place, but it is final. It's a very important aspect of arbitration. Let's move on to the next area, which is litigation. And so litigation is what we all know about from watching Law and Order and all of the other legal shows on TV. And in litigation for associations, we have an option of filing in 2 different levels of courts. The Justice of the Peace level, which is a local court, sometimes called small claims court, or a state district court. So any of the district courts are generally county-based, and there's a county family court or a county district court. So those are the 2 levels. Your attorney would make a decision on where to file. There's some differences, so let me just go through those real quickly. The differences are, for example, in filing fees. Less expensive in JP court, more expensive in a district court. So under $100 in a JP court, over $200 in a district court. Backlog. JP courts, generally you can get into court very quickly. District court can be months and months and months before you get to court, depending on the particular county you're filing in. Formality. An attorney is optional in JP court. It's very relatively informal. Whereas when you go into district court, it's very formal. There are motions, there's no interrupting, there are objections, and all of those things that happen, and you really, really, really need an attorney. You can represent yourself, but for an association, your attorney is going to be there. Limit of authority. Here is the big, big problem of JP courts. JP courts have no authority in a collections matter, for example, to authorize a foreclosure. Can't do it. They can only say, yep, you owe the money. And on a deed restriction type case, they don't have what's referred to as injunctive relief. In other words, they can say, yeah, you should be painting your house, and I'm going to award legal fees. But they can't give you an order, you must paint your house. That's an injunction. It's a requirement of the court. So you might get a judgment in JP court, and it's going to be a money judgment, but you don't necessarily have the teeth to collect that judgment or to force a deed restriction issue to be resolved. And then finally on appeal, if you appeal a JP court case, it basically means you start over at the district level and you start from scratch. So heck, if they're going to appeal it, you might as well start at the district court level. If someone appeals a district court judgment, that goes to an appeals court. And there are appeals courts throughout the state of Texas where it would be heard. The backlog certainly varies there, but that's what an appeal would go to. So for all those reasons, almost all association lawsuits do happen in state district court. Before I get into the anatomy of a lawsuit, what I want to go through is something referred to as affirmative defenses. And on affirmative defenses, these are things that the defendant, the homeowner, might raise if you end up going to trial. And I bring these up because we certainly want to avoid giving them the opportunity for an affirmative defense, but really on a fairness basis. All of these affirmative defenses are things that are unfair if we are doing these things that give rise to these offenses. In other words, these have to do with fairness also in the way we treat our property owners. But from a legal standpoint, we don't want it to bite us on the back end, the litigation end. Okay. It's important that before a lawsuit is filed, that the board of directors makes a business decision as to whether or not to proceed with a lawsuit. It's not sufficient to just say, well, the deed restriction says you can't do this, so we're going to sue. Because you have a fiduciary duty to the association to make good decisions. And if this is, quote, a losing battle, do you want to be spending association funds on something that you're not going to win? So it's appropriate in conjunction with the association's attorney to make a decision on as to how to proceed on a particular item. And some of the factors are going to be, what's the strength of the case? What's the documentation in the case? What are our chances of success? What have other cases that have been tried that are similar? What have they shown? And what's the damage to the community? Is this even visible by anyone? Does anyone even know this violation exists? And finally, the cost. That's a real factor because all of the owners in the association are paying for this litigation, especially if you lose. If you win, then the defendant may be paying these legal costs. But all of those factors are a business decision for the board of directors in determining whether or not to proceed. Now, the chance of success is going to be better if you don't have any of these affirmative defenses out there that the other side could raise. So let me go through each one of them. They're all important, and I'm going to give you real-life examples of these. The first one is statute of limitations. We talked about this a lot in Practical Deed Restriction Management Seminar and in the Architectural Control Seminar. But statute of limitations is this. You must, if you want to proceed against something, you must file a lawsuit within 4 years of the event occurring. Now the clock starts when you knew about this or should have known about it. Why am I saying those two different things? Well, if this is in plain sight, if someone has painted their house purple, then it was in plain sight. Essentially, the day they painted is when the clock starts. If, for example, they did something in their backyard, let's say they built a dog run in their backyard, and your restrictions indicate that a dog run must be made out of wrought iron, and they made it out of chain link. And they did it, and no neighbors told you about it, and you only found out about it when they had a pool party and one of the board members went to the pool party, or in their backyard, or an ACC member did. So for something that's visible, it's when it happened. For something that is not obvious or visible, it's when someone from the association found out about it. That's when the clock starts. When does it end? It ends on the day that you file the lawsuit. So you must file it within 4 years of when you did it. It doesn't end when you send a letter to the homeowner asking them to repaint their house. It doesn't end when the attorney sends a letter to the owner. It ends when you file a lawsuit. So that is a hard and very difficult affirmative defense. If they can prove that 4 years has elapsed, you're not going to prevail in that particular case. The next one is a concept called latches. And this is where the association unreasonably delays its claim to the owner's detriment. So what's an example of that? And again, all these things are fairness issues. So let's say an owner is going to put a room addition on their house. And they're going to, for example, they're going to add a second story to the garage or something, something like that. And they don't submit anything to the Architectural Control Committee, but they start doing work. And the first thing that happens is a sign goes out in front, Joe's remodeling or something. And then next you have a bunch of supplies that are delivered to the property. And all of this is perfectly visible. They happen to live across the street from the president of the association, let's say. And then they start taking off some of the siding on the garage. And then within a week, they're taking the roof off the garage. And then a few weeks later, they're putting decking on the second story of the garage. And then finally, 2 months later, when it's essentially complete, the association says, wait a minute, you can't do that, we're going to sue you. That is a perfect example of latches where the association delayed. They could have told them earlier, before all that money was spent that this is not going to be acceptable. And so that's a really good example of if you see something, we need to do something quickly. That's why we have something we refer to as a cease and desist letter. A cease and desist letter, if we see someone doing something that's going to be expensive and not allowed, then we will immediately create one of these letters. We'll hand deliver it to the property, to the contractor, post it on the door, email it to the owner. We try to get it into their hands immediately. And that letter says, if you don't stop within 24 hours or by tomorrow, whatever the deadline we put in there, but it's a very short deadline, no more than 24 hours. If you don't stop, then we will immediately go to court and get a temporary restraining order to prevent you from continuing this activity. That sounds very extreme, and it is. In all the times that I've been associated with a cease and desist order, and these don't come up often, 100% of the time the owner immediately called and the work stopped. We were able to then resolve whatever the issue was. Sometimes it's just a matter of turning in your plan so we know what you're doing, but sometimes changes have to be made. But that's what we do to prevent a laches defense. We go ahead and stop it as soon as we're able to so that they're not spending any more money to their own detriment. We then have estoppel. Estoppel is the concept of if we tell you something and you rely on it, you should be able to believe us. That's what estoppel is. And so this can occur, for example, if an owner goes to a board member or an ACC member, for example, and says, hey, you know, I want to go ahead and put in a boat shed on my property. What do you think? And the board member says, or the ACC member says, sure, you can do that, but you need to submit paperwork to the ACC, et cetera, et cetera, et cetera. Unfortunately, the owner may have only heard, sure, you can do that, and then kind of zoned out after that point. But if they actually said, sure, you can do that, there's no problem, just go ahead and do it, then the owner has relied on a representative of the association, a member of the board of directors, a member of the ACC, and proceeded with what they received. That is a very, very compelling affirmative defense. What's even more compelling, and we use this as our example at the Essentials of Architectural Control seminar, and that is, what if a ACC sent an approval letter to an owner? And maybe they didn't have all the information they needed, and the owner assumed that, maybe the owner assumed something, but basically they get a clean letter. The plans you sent in are approved without any conditions. And maybe the ACC missed something that it says down in the corner in little letters, and we're going to paint it purple with polka dots. That letter will be introduced to the judge saying, here is the application that said purple with pink polka dots. Here is the approval letter. That's what I did. A judge is going to look at that and say, hey, you told them they could do it. That's not their fault. They relied. They did what they were asked to do by submitting the application. They didn't lie. They didn't hide anything. You approved it. They did it. Go away. So that's a very powerful defense. The last one I want to talk about is waiver. And waiver is where an association, through its either something it writes, puts in writing, or the way it acts, has given up its right to forbid something from happening. There's a lot of words I just said, but basically it says, hey, you've set precedent. When a homeowner complains about waiver to our office or to the board, they're always talking about precedent. They're talking about, well, someone else has a earth tone house that happens to be orange. because they're from Sedona, Arizona, and they think earth tone is orange. But the owner would say someone else has this, therefore you've waived your right to tell me I can't have the same thing. And that, on a guttural level, in your gut, that really does make sense. I mean, if you're allowing someone else to do it, why can you tell this person not to? And you want to be fair. You want to be consistent with everyone. But let's look at how the law looks at waiver. And this is actually one where we have some precedent in the state of Texas in associations relative to waiver. There are only, when this was put together several years ago, there were only 3 cases on point that had gone to an appeals court. When you go to an appeals court, it's not just the judge who has made this decision, but it's the 3-judge appeals court who has sustained that decision. In other words, who has agreed with that decision or disagreed with that decision. And there are 3 cases that are shown right here, and the details are not important as to what was there, but 2 are related to kind of setback lines, and a 3rd one is related to use of a property, businesses versus residential. And in these particular cases, the defense brought up waiver. And the defense showed in all of these cases that a whole lot of other houses in this community are doing the same thing that my client wanted to do. So this association, they waived their right to tell me we can't do it because they've let everyone else do it, either by approving something or just by not disapproving it, by their written means or by their conduct. They've allowed other people to do it. And it's really interesting, if you look over on the right-hand side of this slide, in 2 of these cases, in the first one, 9% of the community, 1 out of 10 owners in this community were doing the same thing, had already been using their home for business purposes. 10% of the community. The appeals court said, no, the association hasn't waived their rights. They can tell you that you cannot run a business out of your home. In the next case, 16%, almost 17% of the homes had this very same setback violation. It was over the front setback in this particular case. And the judge said, 16%, that's not too many. You cannot, or we can prevent you from being the 18th percent, the next person. And so the judge ruled in favor of the association. And in this 3rd case, it was up to 27%. 27% of the owners had this side setback violation. 27%. At that point, the appeals court said, okay, enough's enough. Association, Tanglewood Homes Association, you really have given up your right to be telling folks they can't have a setback violation. And so that's the case on waivers. All of these affirmative defenses are things that the judge makes a decision on. In the case of waivers, it's not that homeowner who's telling you there is one other purple house, so you can't tell me I can't have a purple house. A judge makes a decision on whether or not you've waived things, and the courts in Texas thus far have been generous, if you will, in terms of what constitutes waiver. It seems to be maybe in the high teens or higher is where there really is a waiver. But certainly in the low teens or under 10%, the association possibly could still prevail. Remember, these are not going to necessarily be on point with whatever you're trying to litigate, so you can't use these as hard percentages, but it simply gives you an indication that the courts are going to attempt to help you enforce the restrictions, but you got to help yourself. You got to be consistent. So, with that said, we've now talked about making a business decision on whether or not you even want to file a lawsuit. What are the chances? What is it going to cost? How's a judge going to rule? I didn't even mention the judge is going to be considering equity from the standpoint of, if you have, for example, a house is built a foot over the setback line, too close to the street. It's clearly a violation. There's no doubt there's a violation. And you come before a judge and you say to the judge, here's the violation, here's the proof. The other side admits that it's over the line. And your remedy is for them to tear down this $200,000 house. The judge will say, I can't see the difference. I'm not going to force this owner to forego $200,000 worth of improvements for something that has no value or no detrimental value to the community. So that's an extreme example, but a judge makes a judgment, and one of the factors is equity. All of those go into whether or not to file a lawsuit. But once you do, now we're going to get into the anatomy of a lawsuit. And this is interesting. Hopefully, most of you have not had to go through a lawsuit and don't have any personal experience in this. But let's go through it. From an association standpoint, it all starts when the board of directors approves filing a lawsuit. We're going to talk about collections and deed restrictions. They're both handled the same until after a judgment is obtained. And so the board approves a lawsuit. Many things have occurred first. Statements have gone out, letters have gone out to owners, appeal hearings may have been held, attorney demand letters have been sent out. Eventually, the board makes that decision, we're going to file a lawsuit. The management company is the one who accumulates the package of information and all the detail for the attorney. The attorney would have already sent a demand letter, so may have some information, but now all of the detailed information is provided to the attorney. They prepare a lawsuit. In the document they actually file with the court is called a petition. So they prepare the lawsuit petition. They file it with the court. And again, the district court, it's almost always going to be. They file it with the clerk of the district court. The clerk of the district court gets it all logged in, turns the paperwork over to a constable who then serves the defendants. And there's a couple items here that indicate that you don't have to use a constable, you can use a private process server instead. And a private process server is kind of interesting. These are you almost never see, if you're a fan of Law and Order and all of those legal shows on TV, you almost never see a deputy or a constable in the state of Texas serving the defendants. They always seem to like showing a private process server, and because it works like this. You know, if you know you're getting sued and you are doing what's called ducking service, in other words, you see someone with a gun and a badge show up at your front door, you don't answer the front door. And if you've been sued a lot, you know all the tricks to avoid service. And so if the association's attorney suspects that this may be a savvy defendant, someone who may duck service, they may go ahead and do something by using a private process server. And it looks like this. And so they'd hire a private process server. Typically they've got some, if you watch TV, the private process server is some a foxy lady, and the guy and the defendant is always some guy. So what happens is I'm the defendant, the one who needs to be served, and so I head over to the local bar, and I'm just hanging out at the bar drinking my beer or whatever I'm drinking. Hey.
Hey.
I'm Ralph.
Pleased to meet you. You've been served.
And so, thank you. So anyway, that's what a process server, why you'd use a private process server. Oh, wow. No, just kidding. That's why you'd use a private process server, is to affect service in a place where it may be a little bit more challenging. If you are going through either a private process server or a constable, and you have someone who is avoiding service, there's something called Rule 106 service. Rule 106 is part of the Texas Code of Civil Procedures, and it basically says that after making attempts to serve someone in their hand, to personally serve someone, if you're not able to do that, that you can affix the document to their door, either of their home, their place of work, or literally where you know they hang out. Or you can give it to a person who is 16 years old or over 16 years old who is in the home, their office, or where they hang out. And so that's how you serve someone. You cannot proceed with a lawsuit until you serve every single defendant. If there's a husband and a wife, you can't give both of them to the husband and say, would you hand this to your wife? You must hand it to the husband, you must hand it to the wife. So everyone who's on that lawsuit must be personally served. Once they're served, then we get into what do we do now? We've served the defendants, and it all depends on what the reaction is. So we've served them, the ball's now in their court. And so they can do one of three things. They can maybe not answer the lawsuit. Now, what is an answer? That lawsuit petition that you receive is going to say on it that you must appear in court. And appear doesn't actually mean physically appear, it means to provide an answer to the court, by the first Monday following 20 days after service. In Texas, it always has that weird language. Why doesn't it just say you must answer in writing by September 7th or something like that? It has that weird language. So basically, it's about 3 weeks from the time you are served until you must file an answer with the court. So one option is you don't file an answer. An answer is something in writing that you provide to the court in response to this lawsuit. Another option is you file an answer with no fact issues. I'll just define that in a moment. Or you file an answer with fact issues. And depending on what you do determines now the ball is back in our court and what we do. So let's start with if the defendants do not file an answer. Under Texas law, if the defendants do not file an answer to the lawsuit, the plaintiffs, us who brought the lawsuit, are entitled to a default judgment. In other words, we can go back to the court, give the judge a motion for default judgment, which basically says, we win. And the judge, under law, can sign that. The owner does not have their right to a day in court if they don't answer that lawsuit. That is maybe a harsh remedy, but it's very important that the owner respond to this. They can't just keep their head stuck in the sand. They need to respond somehow. Eventually, they're going to need to show up in court. But if they don't respond at all, we win. We don't always win because in many cases, the judges don't want to sign a default judgment. They want to compel that person to come in front of them and at least try to defend themselves. But under the law, we are entitled to a default judgment. What if they do file an answer? There's two things that they can state in their answer. One is they can raise questions as to what the facts of the case are or not. So let's take, for example, a collections case. We are alleging they have not paid. So that's our allegation. If they come back and say, yes, I did, I have canceled checks, only a judge or jury can then look at our allegation, our records, their canceled checks, and make a decision as to what the facts are in the case. So if they say, I have canceled checks, they've raised facts that someone has to decide on what's true or not. They might send a response back. We've said they haven't paid. They send a response back saying, well, I don't use the pool, I shouldn't have to pay. They haven't raised any facts, they haven't disputed the fact that we have alleged they haven't paid. So they have not raised any fact issues that a human being needs to decide what's true or false. And so if they raise fact issues, then that's when we actually go to trial. We begin the discovery process. We ask them to produce information and all sorts of things like that. We go to trial. If they don't raise the fact issues, so yeah, I didn't pay because I don't use the pool, then we are entitled to submit to the judge what's called a motion for summary judgment. In other words, we lay out our whole case, proving that they haven't paid. We submit it to the judge. The judge says, I agree, you win. We don't even go to court. So depending on what the owner does after they're served, depends on the trajectory we take. The fastest is default judgment, not quite as fast as the summary judgment, and the slowest one, because we need to wait for a hearing, we do discovery, we do all that stuff, that is where we actually go to trial. So, one way or the other, we're going to get to the point where we're going to get a judgment. So at some point the judge will sign a default judgment, he'll sign a summary judgment, or they'll make a ruling from the bench and in a bench trial, or there may be a jury that makes the decision. From the time the judge signs that judgment, any of the three varieties of judgment, the judgment doesn't actually become final until 30 days after that date. So for a 30-day period, we're all on hold. Why is that hold period there? Because a defendant, someone who has just had a judgment entered against them, has 30 days to appeal that to an appeals court. And so until it's not appealed, it's still a pending judgment. So after 30 days, it becomes final. At that point, we can start doing our effort to collect. Now, certainly, if it were a collection case, for example, the day the judge signs it, the guy could pull out a checkbook and write us a check for everything that's owed and everything the judge awarded. That doesn't always happen. If they were having trouble paying their $500 assessment, they're probably going to have a whole lot of problems paying the $500 plus several thousand of legal fees, plus course costs and everything else. So generally we need to enforce the judgment. The attorney gets something called an abstract of judgment. That is simply a one-sheet piece of paper that they get from the court that summarizes the judgment. On this date, this plaintiff sued this defendant at this court, and the judge made this decision. It's one page, certified by the court. What we do with that is then we file that in the public records. All of a sudden, the whole world now knows that we have a judgment against whoever the defendant was. And not only that, and of course, when it's in the public record, that's going to affect their credit, it's going to show up all sorts of places. But not only that, if we happen to know that they own property, maybe this judgment occurred in Harris County, but they own some property up in Austin and maybe at Canyon Lake, we can file it in all sorts of different counties just so it shows up everywhere that anyone might be looking. It just costs a few extra dollars to file it all over the place. And so that's the abstract of judgment. The attorney then sends a letter to the owner as soon as it becomes final after that 30-day period, and we'll say, hey, we got this judgment, would you please pay, would you please paint your house, would you do whatever the judgment was. And hopefully the owner will then want to get on a payment plan, maybe needs a little more time for an extension to paint the house, whatever, but we're on the trajectory of getting it resolved. When they take care of it, we release the abstract of judgment. Unfortunately, somewhere between the attorney's post-judgment demand letter and it getting resolved, we often have to push a little bit harder. And so that's where things kind of separate. On a collections case, the association has the opportunity to do what's called execute on the judgment. When you execute on a judgment, we first start by getting what's called a writ of execution. It's a piece of paper that is given to the constable that says, hey, there's a judgment, go collect this for the association. And this is a collection case. And so there's a couple ways to execute. In Texas, we can seize property. So a constable might go to the door of the defendant and knock on the door and say, hey, I've got this judgment against you and I'm here to collect property to satisfy this judgment. Do you have any non-exempt property that I can seize? The owner is going to say, no, and the constable will leave. It truly is just like that. They're not going to burst into the house. They're not going to be just grabbing stuff. The constable's going to leave. And the owner is never going to say, oh, sure, come in here. I've got, gold bullions sitting on the coffee table. Grab as many as you need. That won't happen. And so for associations, the execution part almost never goes towards seizing personal property type things. There are some cases where it does, where a business maybe is involved. But for individual owners, almost never goes that way. The way it does go is to a foreclosure. So that's seizing real property as opposed to personal property. And in that particular situation, there's a whole long process that the attorney goes through in order to make sure that the owner has all the protections relative to foreclosures. The end result is maybe we actually do foreclose and take title to a property. That is exceedingly rare that that ever happens, but that's our ultimate remedy on a collections case. I'm going to take a quick question here, and then I want to get into the pathway for a deed restriction issue. So what sort of questions do we have?
Okay, we have a question about what is an order of sale that's prepared and filed.
Well, terrific. So as part of the question, as you heard, was what's an order of sale? As part of the foreclosure process, if we're going the foreclosure of the real property of the house, then the constable must post notice at least 21 days in advance of an intention to sell a property in order to satisfy a judgment. And so that notice of sale is posted, the order of sale is posted in a public location, typically at the same site where the foreclosure sale will occur. I'm going to show you some pictures in a second I'll actually point out where that order of sale is posted. And oftentimes it is also posted in a newspaper of general circulation in the county at which the property is located. So an order of sale is that actual posting, we're about to foreclose on the property at least 21 days in advance. Great question. Now let's talk about the deed restriction side of this particular slide. And what we have here is that on deed restrictions, we've got two things we want to satisfy. On the collection side, we just want the money. On the deed restriction side, we both want any money that was awarded, but most importantly, we filed a lawsuit because we have a violation we want corrected. So in this case, we're not going to foreclose. You cannot foreclose on a property for a deed restriction issue or a judgment associated with a deed restriction. But we want this violation taken care of. We want that house painted. We want whatever was awarded, we want it taken care of. And when the owner hasn't, when they haven't abided by that post-judgment demand letter, when they haven't done what the court ordered them to do in that injunction, the order from the court that you must do this, what the association's attorney will do is they will file a motion for contempt. In other words, that owner has ignored the judge's order. That's contempt of court. We all know that from, again, watching TV. That's a motion for contempt that is filed. And the judge then orders a show cause hearing. What does that word mean? It means me, the judge, I'm ordering you, the person who has a judgment against you, to come in front of me and show me a reason, show me a cause that I should not hold you in contempt. So that's why it's called a show cause hearing. And so we all go back to court, and the person has to explain to the judge why he ignored his order. Now, judges don't get personally involved or emotionally involved with these things until someone ignores what they say, and then they get kind of mad. And so, you know, if you don't pay a judgment, go handle that yourself, association. But if you've been ordered to paint your house by the judge and you don't do it, they get emotional. They get personally involved. My favorite one, you may have heard this story, we talk about it in the deed restriction seminar, is the only time that I've ever been to court associated with a show cause hearing was in a case many, many years ago before the Telecommunications Act, where an association prohibited large satellite dishes. This person had a gigantic satellite dish. It was either an 8 or 10-foot satellite dish in view. The judge ordered that person to take it down. They didn't. We dragged them back into court. The person had no defense to not taking it down. He was ordered to do it. The judge, right there in court, ordered the constable to handcuff this guy and throw him in the lockup. That was, that's kind of scary, but the judge was not amused by this person ignoring their order. He ended up getting out the next day. But why was the judge so incensed in this particular case? Well, the defendant in this particular case was an attorney, and he certainly did not like the fact that an attorney was ignoring his order. So that he took care of the situation, put him in jail. The attorney was out the next day, and the satellite dish was probably down before he was actually released from jail, but it was within 24 hours that satellite dish was down. So that's one of my favorites. Well, that's the anatomy of a lawsuit, and one of the things that I wanted to move on to is along the lines of collection. Sometimes foreclosure does occur. And one of the things that we sometimes have to deal with in an association is there are several types of foreclosures which can occur. And let me just check what the time is here, because I'm not sure. Okay, that's what it is. And there can be foreclosures by a mortgage company. So someone gets behind on their home payments, maybe loses a job or something, and they can't make their mortgage payments. The mortgage company will foreclose. They have a right to what's called a non-judicial foreclosure through when you sign the deed, the note on your property, you give the bank the authority to just say we're going to foreclose, go through a few formalities, and then march down to the courthouse steps on the first Tuesday of the month and sell your property. Except in rare circumstances, the association has no recourse there. Our lien is subordinate to the mortgage lien, and therefore, when that foreclosure occurs, the new owner, whoever buys it, or the mortgage company, has no obligation to pay any of those past due assessments. They must pay from that day forward, but nothing from the past. Technically, the former owner has a personal obligation to pay those, even though they no longer own the house. It's totally impractical to go after the former owner. If they've been kicked out of their house, they've got serious financial problems. We have no leverage at all over them to try to sue them and collect from them. So for all practical matters, if a mortgage company forecloses everything from that day back is absolutely uncollectible. Now, a taxing authority can also foreclose. So if someone has not paid their assessments and they also have not paid their taxes, a a taxing authority, city, county, levy improvement district, mud district, whatever it might be, could initiate foreclosure proceedings. They actually have to file a tax lawsuit to get a judgment that allows them to proceed with the foreclosure. Typically, the other taxing authorities will join in that lawsuit, because if you haven't paid your school taxes, you probably haven't paid your county taxes either. And once a judgment is rendered, then at that point, a foreclosure can occur. The foreclosure occurs, the title goes to either the county or whoever initiated the lawsuit, or if there was a third party who bought it at sale, then they get it. Similarly to a mortgage company foreclosure, the association fees are not collectible at that point. And it's even worse from the standpoint of, with a governmental entity, during the period they own the property, let's say they take title to it, and they own it for 2 years, they are not obligated to pay assessments during that period of time. Whereas a mortgage company would immediately have to pay assessments. Taxing authorities and governmental entities do not. Now, an association may initiate the foreclosings. That was the end result, the rare end result of us having funds that are overdue. There's some thought that, associations, this is a homestead state, why can associations foreclose on a property? Well, that was all settled at the Supreme Court level in Texas way back in 1987, so associations really can. This is settled law. Texas Property Code Chapter 209 has a whole lot of procedural items that need to be carried out by the association's attorney in advance of a foreclosure. These are all really good protections for the homeowner, and it prevents any abuses or things of that sort. So these are lots of procedures, but it's really good that these things are in place. Now, when a foreclosure occurs, the person who buys it at sale gets what's called a constable's deed. A constable's deed is a form of what's referred to as a quitclaim deed. A quitclaim deed makes no warranty as to the fitness of the property, whether or not there's other encumbrances or liens or other attachments to the property. It simply says, hey, whatever we own, we're giving it to you, caveat emptor, buyer beware. You're getting whatever you think we have. And so if you ever want to be buying property at a foreclosure sale and you're looking to purchase property that's a homeowner association foreclosure, you need to really be a savvy buyer. You need to know what you're doing and not be buying something that's going to be upside down. Because if there's a mortgage on that property, you're getting that mortgage. If there are liens on that property, you're getting those liens. You simply are getting title to the property with all the baggage that comes with it. So, how do foreclosure sales occur? Well, it's, these are interesting pictures here. This is the Family Law Center in Harris County, Texas, largest county in Texas, and therefore you'd expect it has more foreclosures than others. All foreclosure sales in Texas occur on the first Tuesday of the month. Mortgage foreclosures, tax foreclosures, property owner foreclosures, any types of foreclosures, they happen one day a month on the first Tuesday. That order of sale is posted that was mentioned earlier. And if you look over here, and I'm not sure I can quite point to this, but if you look at the left-hand side, you see some white section over there. That's actually a board that has all the postings on it. It's a big long bulletin board in Harris County. It's probably about 30 feet long, about 4 feet high, that is just packed with these notices of sale. And so you could go over there to the Family Law Center 21 days in advance and you could read what's there, or you could subscribe to a publication which goes and reads all of those and will give you a summary of what's for sale. But what you'll see is a whole bunch of people there. You'll see it's a big glass foyer with a very high ceiling. You'll see people inside and outside. The sales happening inside and outside. You have attorneys who are doing sales. You have constables doing sales. You have people milling all around. The echoes in that place are terrible. And so all you know is that the sale is going to happen generally between 10 and noon or 2 and 4. That'll normally be placed on the order of sale. And so you get there, you try to find the right person who is conducting this sale. They may have 10 or 20 they're conducting. They monotonously read this order of sale with a full legal description, then they open up for bidding. You've got so much noise going around you. You're leaning in, trying to hear what's happening, and it's a real zoo. I mean, it's something to behold, at least once. Let's go to the other extreme, one of the smaller counties in Texas, Bandera County. That is the Bandera County Courthouse. And the county commissioners decide where these foreclosure sales happen, and it is almost always on the courthouse of the county seat of that particular county. In the case of Harris County, it just wasn't going to work there, and the commissioners moved it over to the Family Law Center where they had more real estate. But in Bandera County, and I'm not sure I'm going to be able to exactly point to what's here, but I'll try. Oh, there we go. Maybe I'm pointing to it. If you look right over in this area, right down here, these are the courthouse steps right there. And literally there's 4 steps right there, 1 little door, and that's where the constable stands, and anyone who is bidding just stands on the sidewalk below it. Right over here, if I can finally get to it, I'm not going to, under the limb of this tree, you see a little white thing? That is the bulletin board. It's about 2 feet by 3 feet, and that's where the postings of the orders of sale occur in Bandera County. And it only takes up, one small portion of it. So those are the 2 extremes of what actually happens at a foreclosure sale. Let's move on to what can happen at a sale for an association. I'm going to go through these scenarios real quickly, but here's a scenario where we got a judgment and it's for $3,000. All in, that's how much is owed to the association. And that in this particular situation, the cost for the constable to post and conduct the foreclosure sale is $500. So what are the possible outcomes? The one possibility is no one shows up and bids, and the association doesn't want the property, and so it could be written down on what is owed here. So basically nobody wants the property. Nothing happens. The association needs to pay the constable $500, and the property is still owned by the property owner. Nothing happened. So that's not a great situation. The second option is we don't have any bidders, but the association does want the property. Maybe they've determined there's some equity in the property, and so they go ahead and they bid the minimum, which is the constable starts the bidding at their fee. So they'll start at $500, and the association bids $500. The constable says, sold, struck off to the association. And so the association pays the constable the $500 for the posting, and then they get a deed to the property. They get a constable's deed to the property. Well, let's move on to the next situation where you actually have some bidders out there, but there's not a whole lot of interest. Finally, they get the bidding up from the $500 starting price to $2,000. And so the association doesn't want the property, so the constable says, sold for $2,000 to, this third party over here. Well, in that case, the association gets $500 and the association gets $1,500. We didn't get our whole $3,000, we only got $1,500. Better than nothing, and very importantly, we don't own the property. In almost all cases, you don't want the property. You don't want to potentially have to evict someone. You don't want to have to maintain the property, put insurance on the property, hold the property for a 180-day redemption period before you can actually get rid of it. So it's good that we had a third party who bought it. The fourth scenario here is where we do have a bunch of bidders. We've got some smart bidders out there. They've gone through and determined there's not a whole lot of baggage on this property. The mortgage is small, the equity is large. And so they start bidding, and it finally peters out at $20,000. Constable says, sold for $20,000 to you. And what happens then? Constable gets $500. We get our full $3,000. What happens to the rest? That actually goes back to the person who just lost the home. The association cannot be unjustly enriched by this, and so any excess eventually will go back to that particular owner. And frankly, with that, potentially they could have paid their assessment to us. But it's too late at that point. So the bottom line, why would the association ever want to take title to a property? Well, maybe if there's a lot of equity in it, but chances are if there's a lot of equity in the property, a third party, a savvy buyer will be out there getting it. In one of our seminars, I talk about a strategic foreclosure. This would be a situation where maybe the house has been abandoned. It's being used as a drug den. It's a health and safety issue for the community. In that particular example that I gave in the other seminar, this was a house that was owned by someone who is now a guest of the state of Texas in Huntsville. And so clearly, they were not going to be able to do anything with the property. They weren't going to be able to pay their assessments. And it literally was being used as a drug den. The association foreclosed on the property, paid the mortgage, ended up having to refurbish the whole house, and made a couple $1,000s on it. So in that particular case, the whole objective was to take control of the property to protect the community. We're going to zip through bankruptcy because I think we don't have too much time. And so bankruptcy, there's a lot of terms here, Chapter 7, Chapter 13, and whole cast of characters. But what I want to get to is how that impacts the association, which is over on slide 30. And the way it impacts the association is this, that when an owner is in bankruptcy, and it's towards the bottom of the slide, an association may not proceed with delinquent collections. We can't be applying late fees. We can't be even sending statements that imply anything is owed. We need to be working through the bankruptcy trustee in the case. In other words, the person assigned by the bankruptcy court to administer this case. We may not withhold any rights. We can't say, hey, your assessments aren't paid, you can't use a swimming pool. Your assessments aren't paid, you can't vote. State law prevents that one. But in addition, back when we could withhold voting rights, you would not be able to in the case of a bankruptcy. And we may not pursue deed restriction violations to any degree that would have a financial impact on that particular owner. So we can't tell them they need to paint their house. That's going to cost money. Re-roof their house. It's going to cost money. We can tell them that they need to put away their trash cans. But that very much limits the things that we can do even in the deed restriction side. If a situation is intolerable, we can go back to court and ask for what's called relief from the stay. The stay says, don't do anything with this particular person. relief from stay allows us to then proceed. You see relief from stay often from maybe car companies who have given a loan on a vehicle, and they want to be able to take the vehicle back. Sometimes, in limited cases, the bankruptcy court will allow that. They will grant that relief from stay. From an association standpoint, I've only seen one case in all the years we've been doing this where an association had a reason to go back to court for relief from stay on a bankruptcy. It's very expensive because you're going in front of a federal judge. It's no longer a state judge. Your attorney may not be licensed to practice in federal court. There's all sorts of reasons why it's impractical to try to get a relief from stay, but it may occur. Okay, the last couple things I want to go through, and we'll go through them quickly. The very last slide is the most important, but let's go through the types of insurance an association needs. Directors and officers liability insurance. Absolutely every association needs this. There's no question about this. This is what protects board members, volunteers, for any claims about their decisions or lack of decisions. So if we send someone a deed restriction letter and they want to sue the whole world, including the board and the association and the board members individually, this is the policy that protects you. It's extremely important that every association have directors and officers liability policy. You guys aren't paid. You shouldn't have to be defending yourself in court. Then we get into, these two are generally packaged together, commercial general liability and property coverage. This is the same thing you have on your home. You have a combination of property coverage, so if your house burns down or something like that, property coverage is there. So if the association owns any property, whether it's park equipment, swimming pool, clubhouse, common area fences, entry monument, anything that could be damaged, you want property coverage. Commercial liability, this is kind of the slip and fall type coverage. It covers two things. It covers bodily injury to others. In your home, someone's walking up the front step and trips. On a common area, they're walking down a sidewalk and trip. And it also covers property damage to others. In the case of a community association, let's say you have a tree at the park, and during a storm, it falls onto someone's house and damages their fence and their house. That would be a general liability claim because it's property damage caused to someone else, in this case, an adjacent homeowner. So those are almost every association needs these, certainly the general liability, because even if you don't own any property, but you have someone mowing your entry esplanade, and the mowing crew kicks up a rock that breaks the window in a passing car, or you're mowing the property, or you maintain the center esplanade, the water's running into the street, someone's walking down to the street and they slip and they blame you for that. So there's all sorts of reasons you might want commercial liability policy, even if you don't have any property. And if you don't have any property, it's relatively cheap. Business automobile, this would cover board members or volunteers using their personal vehicle for community association business. It's secondary to your own policy. And many years ago, I spoke to an agent who's been covering associations for, at that time, 25 years. And he had never seen a claim on a business auto policy, simply because they're secondary to your own personal property. They're inexpensive, but if there is something catastrophic, for example, you're delivering something in the community and you hit a person and they're hurt, the medical bills could be very large, and that would be very helpful to have this. Crime policies, they protect dishonest acts. The better policies and the ones that are available through the C.I.A. Services Master Insurance Policy include some emerging and very dangerous threats, and the more important threats these days, frankly, and that is various cyber crimes and even social media fraud, which at some other point I can describe that, but that's where someone fakes you into thinking they are the Prince of Nigeria, for example, and so why don't you just give us your account numbers? Hopefully most of us would not fall for that particular one. Workers' compensation is there in case someone claims, certainly if you have employees, you need workers' comp. But if you don't have employees, someone could claim, for example, a grounds maintenance company employee could claim that the only reason they got hurt was because they were working in your community and their company's policy just happened to have lapsed. So again, it's not something that would normally come up that you'd ever see a workers' comp claim, but it's relatively inexpensive. Umbrella policies are a very inexpensive way to ratchet up all your limits. You may have a $2 million limit on your general liability policy, but if someone drowns in a swimming pool, that's probably not going to be adequate. The umbrella policies through our master insurance program are $15 million on top of all the underlying, on top of the D&O liability, the general liability, the non-owned auto. So this right here is one of the most important things I need to point out to you, and it's the last slide that we have. And that's something called the Texas Charitable Immunity and Liabilities Act. It was put into place back in the 1980s, and there's a lot of words here, but essentially the bottom line is what's right here. As long as an association maintains the minimum liability insurance policies, I'll describe that in just a second, then its volunteers are immune from personal liability. By state statute, you cannot be personally named in a lawsuit where they're complaining about something the association did. And the association's liability is going to be limited to whatever the policies you have. Those are both very, very important. Your personal immunity. You don't want to have to defend yourself. You don't want the association to have to defend yourself. You're a volunteer here. So that's what this Charitable Immunity Act is all about. The other part of it is that the association's liability will be limited to whatever your insurance policies are. So in other words, if you have, in the case I just gave you, $2 million general liability, you have $15 million of umbrella liability, and someone dies in the pool and alleges it's because of wrongdoings of the association, the maximum claim that they could have is $17 million. They couldn't exhaust your policies and then start seizing assets of the association. So that's extremely important. So if it's a general liability claim and you have the underlying general liability policy, this comes into effect. If it's a general liability claim and you don't have that policy, this doesn't help you. You must maintain those minimum underlying policies. Well, that is everything we have for tonight's webcast on advanced topics for board members. We went through a lot of very detailed things. There weren't too many questions, but if you have any questions, feel free to send them to anyone at C.I.A. Services, and we'll personally respond to your specific questions or concerns. Our next seminar coming up next month is super budgeting. Extremely important. You're starting to look at your budgets. This gives you the overall concepts that'll make it much easier for you to understand how these super budgets work and how they are just a tremendous tool to help you in future planning. And then the seminar after that in October is a repeat of our board member orientation seminar. So if you missed it earlier in the year or you've been elected since the last seminar, please attend that one. So everyone, thank you so much for attending. See you next month.